Hello and welcome to another episode of A Current Affair. Tonight we investigate the Qantas Industrial Relations Dispute of late 2011. This dispute has had a hard-hitting impact on Australia's aviation sector with severe repercussions on the Australian economy, Qantas Airlines passengers and Qantas itself. The dispute was a battle between the combined unions and their employee members against Qantas, critically reviewed and acted upon by Fair Work Australia and the federal government. The outcomes, criticisms and standpoints on the dispute have paved the way for legislative change and have challenged the decisions of major parties in response to the dispute. After announcing global lockout on their aircraft, Qantas were in major speculation with the federal economy, with the lockout costing approximately $20 million daily. The combined unions, comprising the Australian and International Pilots Association, the Australian Licensed Aircraft Engineers Association, and the Transport Workers Union, launched protected action against Qantas after enterprise agreements lapsed upon speculation of Qantas' focus on developing a more sophisticated Australasian airspace route, which endangered job security in most of its sectors. Protected action refers to action taken by a union and its employees which is compliant with Fair Work Australia regulations on the basis of wagering existing enterprise agreements between employers. On Saturday the 29th of October 2011, Qantas CEO Alan Joyce announced lockdown of all Qantas employees due to commence the following Monday as precautionary action in response to the firing claims launched under the three unions. Under this action, he ordered all en route aircraft cancel further departures upon arrival of their existing destinations. Consequent to the order, Qantas thus had no active flights of domestic or international routes. Joyce had quoted, "I announce that under the provisions of the Fair Work Act, Qantas will lock out all those employees who will be covered by the agreements currently being negotiated with the three unions." Joyce also quoted he responded in such way as it was the only form of industrial action he could launch in defence of the claims. All three unions had agreed, over the duration of the dispute, to bait Qantas slowly with their approach to the claims and demands. Under review of international operations, Joyce and the Qantas team had been considering airline expansion to Malaysia and Singapore in response to the market share drop between 2001 and 2011, particularly within the Asian aviation market. The international section was quoted as being precarious by Steve O'Neill of the economic section of the Parliamentary Library of Australia. In the same report, it was also quoted that Qantas' international sector's passenger makeup dropped 15% between 2000 and 2010. To enable this expansion, Qantas had to consider the appropriate changes to their existing workforce and conditions. The AIPA were the first to launch industrial action on the 23rd of August 2010, when the union canvassed its Qantas employees in Raleigh of the issues of the new enterprise agreements which were threatening to compromise to lower rates through relying on subsidiaries like Jet Connect of New Zealand. This was threatening to the job security of domestic and international pilots within the company, and the union responded by gathering the responses of the pilots at risk. Upon recognition of these issues, Fair Work Australia granted the AIPA a secret ballot on the 26th of May 2011 in regard to proceeding with protected industrial action. Through this action, the AIPA aimed to direct all Qantas pilots to the terms and conditions run under Qantas, not the entity's regulations. This is so that their terms and conditions would not significantly differ if they were transferred to Qantas subsidiaries. The AIPA believes that Qantas' response was disproportionate in that the initial action launched by the AIPA did not constitute a reasonable means for Qantas to order a lockout in response. Commencing the lockout, Qantas pilots responded by explaining the threat of their job security to passengers via intercom. Amidst the dispute, the pilots were reserved in industrial action, yet they showed great concern to the decision of Joyce and the impact it had on them. The pilots, backed by the AIPA, filed an application that Qantas' lockout response be reviewed in a judicial manner. By filing this application, the pilots' intention was to justify the disproportionate response. The Australian Licensed Aircraft Engineers Association launched its first action on 15th of February 2011, as the existing enterprise agreement with Qantas terminated in late 2010. As a result, the union launched claims regarding the job security of engineers within the heavy maintenance facility for the incoming A380 fleet. Later in March and May, the union proposed strike action and employees threatened to finish work earlier. However, progress of such action had failed when the negotiations between the union and Qantas hit a brick wall. This was said as Qantas refused to comply with the action launched by the union. The Transport Workers Union took protected industrial action against Qantas on the 27th of July 2011, after Fair Work Australia granted such action to take place through a secret ballot like the ARPA ballot. This action arose as a result of existing enterprise agreements, wages and working conditions, and aided to the other two unions taking action against Qantas also. Qantas' existing enterprise agreements with the Transport Workers Union were inadequate in the eyes of the employees, therefore they strived towards negotiating such agreements to better entitlements through protected industrial
The lockout
action.
starts on Monday night, but the airline's CEO has grounded all aeroplanes immediately.
This is a very tense environment. Individual reactions to the lockout decision may be unpredictable, and for this reason, as a precautionary measure, we have decided to ground the Qantas international and domestic fleets immediately.
The grounding of the fleet itself was Joyce's response to the oncoming action from the combined unions, with the intention of resolving all industrial matters before abandoning the lockout. The grounding came subsequent to Joyce locking out all staff of the relevant unions. Initially, it was also stated the lockout and grounding order would remain active until unions dropped their unreasonable demands. Under such circumstances, lockout was the only protected action Joyce could take in response to the union's action. Amidst the dispute, the federal government prompted Fair Work Australia to solve the ongoing situation. Before announcing the lockout, Joyce contacted Prime Minister Julia Gillard, explaining the situation he faced, and that until disputation settled, he would ground the entire Qantas fleet. On the 31st of October 2011, Fair Work Australia announced termination of all industrial action covered under Fair Work Act Section 424. Subsection D constituted fair grounds of intervention, whereby such subsection states termination of industrial action is acceptable if the Australian economy is threatened. The parties had been allowed 21 full days to solve the problems and come to reasonable terms regarding enterprise and bargaining agreements.
We need to fight it for everyone.
After the 21-day period, none of the unions were able to meet on any enterprise agreements, but on the 19th of December 2011, Qantas supposed that the Australian Licensed Aircraft Engineers Association consent to an agreement under Fair Work Australia which stated all employees of such union will receive a 3% wage increase and better job security of active Qantas engineers. Upon Fair Work Australia's endorsement of such proposal, this also expanded to include less restrictions on extended hours, a central issue of the initial enterprise. On the 22nd of March 2012, the Transport Workers Union and Qantas were subject to arbitration hearings regarding the dispute. Results of the arbitration are disclosed to only the Transport Workers Union employees themselves. On the 10th of November 2011, the Australian International Pilots Association was the only union to challenge Fair Work Australia's termination decision. The union took the matter to the Federal Court of Australia. On the 10th of May 2012, their appeal was deemed a failure when the Federal Court found that under such action taken by the combined unions, Joyce's lockout was fair, considering the fact that employer action does not have to be reasonable, rational, or proportionate. All en route passengers subject to Joyce's lockout decision were in jeopardy. This resulted in major controversy towards Qantas' lockout decision on its customers, both domestic and international, even though the response was in defence of the union's combined action. Passengers were both apprehensive and enraged of the situation and concerned towards the likelihood of upcoming flights. Qantas passengers were refunded all relevant expenses and offered competitive airfares from numerous airlines, but Joyce announced all Midway passengers would be offered follow-through airfares if they were severely displaced. All passengers were thus reimbursed to the fullest amount and were able to continue to their following destinations with the competitive airfares resultant of the lockout. Locking out all Qantas aircraft majorly influenced the Australian economy itself and lost tourism especially. According to Daniel Gershwind of the Queensland tourism industry, the grounding was a nightmare for the industry. Since tourism comprises around 3% of Australia's GDP, this was a serious problem threatening Australia's economy. The disputation cost the industry around $15 million in lost airfares, tourism, and the expenses of the dispute itself. According to the Australian Bureau of Statistics, tourism GDP grew 5.3% during 2011 to 2012, but it is reasonable to say this rate may have been, to a reasonable extent, diminished by the 2011 aircraft grounding and Qantas' reputation following the dispute. Over the same period, the economy rose 4.7%. During this interval, the tourism industry contributed an estimated $112 million daily. Austrade, under the International Visitor Survey also concluded there were 10,375 less overnight stays at the end of 2011 compared to the end of 2010. It is also reasonable to state this occurred as a result of the dispute. Tourism was at a standstill until Fair Work Australia authorised the termination of the lockout, whereby incoming flights could recover and proceed. This was done as of Section 424 of the Fair Work Act. As effect of the lockout, Prime Minister Julia Gillard felt the need to bring the disputation to an end. Due to the lack of legislation, the Prime Minister consulted with Fair Work Australia to apply the relevant sections and proceedings to the disputation, upon which 21 days were granted for the dispute to appeal as effect of the lockout. But no good faith bargaining agreements were met, and Fair Work Australia terminated all industrial action under Section 424 as well as Section 431, in spite of its threat to the federal economy. Amidst the disputation, on the 5th of October 2011, Qantas publicised acts of threat to all relevant employees who continued to proceed with working once the lockout had been announced. Based on the situation, this was presumably action led by union members against Qantas employees who continued to work amidst the dispute. According to Joyce, himself and his colleagues received numerous death threats in effect of the lockout. Employees' cars who refused strike were also trashed. It was also argued, however, by the union leaders this claim was fabricated to incorporate the media, promoting sympathy for Joyce and his employees. As a result of such issue, Joyce took the situation to the local police, upon which they proceeded with reviewing such allegations under the warrants they were granted for the basis of investigating the matter. All criminal-related acts were therefore, if found necessary, dealt with under the harassment, stalking and threat sections of the Criminal Code Act 1995 and Brodie's Law. In terms of the lawfulness of the actions of each party, according to the Fair Work Australia, the Qantas lockout and grounding action was lawful in terms of response of union demands. Fair Work Australia's intervention and termination was compliant to Section 424 of the Fair Work Act. The federal government had no grounds of intervention due to the nature of it being an industrial dispute. Actions of the unions were lawful, as the purpose of a union is to negotiate enterprise agreements, which is what was done. However, if such unions were indeed responsible for threats, all such threats were unlawful and unprofessional in the context of an industrial dispute, and could be held accountable under the Criminal Code Act relevant to the jurisdiction the threats occurred in. Threats were unlawful on behalf of the relevant employees. It can be argued that the duration of the dispute was indeed the most detrimental issue to the aviation industry and the federal economy. After offering the parties 21 days to mediate through arbitration in order to reach fair bargaining terms, they failed to do so. Meanwhile, due to the complex situation which spread across 2011 and 2012, there was no immediate solution to the disputation. Such disputes slowly settled after the compromise and tertiary effect of numerous parties to the dispute. The depth of the problem resulted in Fair Work Australia resorting to dropping the bargaining claims to focusing on resolving the dispute and trigger of the suffering economy. The dispute was solved under the relevant sections of the Fair Work Act, and such initial claims by each union were then arbitrated at later dates concurrent to the lockout. The dispute cost on average $15 million each week due to lost and reduced airfares, lost tourism and expenses of the dispute itself. Meanwhile, when the grounding was in place, Qantas was losing around $20 million daily. Furthermore, the reputation of Qantas deteriorated and share prices plummeted following the dispute. It took around 5 years for the shares to increase back to their initial price, around $5. Employees were threatened as a result of the dispute, presumably committed by the unions against the employees that refused to strike.
YouTube has been used, online has been used, there's been email, there's been phone calls, and there's also obviously been letters which have been sent not only to the workplace but individuals' homes.
Olivia Worth is one of those individuals. So is Alan Joyce, the CEO. His letter called him foreign filth.
It's coming soon, Paddy. You can't even see it. The unions will fight you.
Alan Joyce has written to his 35,000 workers warning of serious...
As a result of the events leading up to the dispute and the issues affected amidst the dispute, industrial relations legislation and regulations may change to give powers to Fair Work Australia that allow them to intervene in disputes early. This meaning a system which gives such organisation the power to exercise termination upon any actions to a dispute if such actions are reasonably likely to cause harm to the federal economy or associated parties of the dispute. In doing so, the relevant amendments should be made to the existing Fair Work Act to grant such right. It is also argued that future industrial relations laws should, to an extent, allow the government to intervene if such disputes concern the Commonwealth. On the 27th of February 2012, Adam Bent MB devised a bill to the Parliament with the key intention of restricting employer lockouts. in rally of proposing legislation that gives the government powers to intervene on industrial matters. This was, of course, as a result of the lockout ordered by Qantas CEO Alan Joyce, as such lockout came to the concern of the federal economy. To prevent the same situation from reoccurring, it is recommended Qantas maintain positive and responsive relations with their unions, Fair Work systematically analyse disputes early and prevent parties from taking protected industrial action if such action poses any threat to the economy or to the parties involved. It also recommended, unlike the Qantas dispute where the termination of action was delayed, Fair Work develop a system of intervention which allows termination of any form of industrial action early, and furthermore prior to detrimental outcomes if potential of occurrences are high enough. Federal government be allowed power to act solely or on behalf of Fair Work Australia to solve disputes harming the economy, as the status of the economy is a key field the federal government must maintain and observe. In future, unions must compromise on demands to a reasonable level. Union members must also ensure protected action does not escalate to the point of threats or harm. Employees must also abstain from intervening in criminal-like acts, even if resorting to such acts would benefit such party to the dispute.
The summer holidays, it will shake consumer confidence, and we cannot have an industry that is viable, a tourism industry that is viable, without consumer confidence in our transport network.
That is all we have time for on A Current Affair. Thank you for listening, and good night.